if you've attended my presentations before, you'll know I tend to go pretty deep very quickly into legal nuances. So this year, my friend and co-presenter Natalie Hadley will try to bring my content back down to earth. And as before, we'll be focusing on what's going on in the courts, and we won't be focusing so much on what's going on in settlement agreements. Also, if you're a legal geek or you need to talk to legal geeks, be sure to get the handout that accompanies our presentation, as it includes the citations to the legal cases so you can look them up later. So to kick things off, my name is Ken Nakata. I used to be a senior trial attorney in the Disability Rights section at the U.S. Department of Justice. During my 12 years at the Justice Department, I was fortunate to work on a huge variety of cases under the ADA that covered topics ranging from architectural barriers to mental illness and effective communication. During the second half of my career at Justice, I focused more on technology. I represented the Attorney General in the original Section 508 rulemaking. I also served as lead counsel to the federal government's Section 508 working group, which brought together all of the different federal agencies to make the federal government's IT systems accessible to people with disabilities. Since leaving the Justice Department, I've been involved in hundreds of projects involving digital accessibility, and I've advised dozens of attorneys and law firms around the country about digital accessibility. I was also selected by NASA to be their lead consultant, to help ensure that educational STEM programs funded by NASA are accessible to tomorrow's generation of scientists, mathematicians, and doctors with disabilities. But letting a lawyer talk about himself is always dangerous. So I'm going to turn it over to Natalie.
Hi, everybody. I'm Natalie Hadley, and I'm the Vice President of Outlook Business Solutions. We're a marketing and digital accessibility agency that exists to create earning opportunities for knowledge-based workers who happen to be visually impaired. My role for the organization is as the lead marketing strategist and business development. We are a social enterprise that helps organizations recognize the value of accessibility in their consumer and employee-facing marketing. And on a personal note, I'm the mother of a 26-year-old son who suffered a traumatic brain injury at the age of 3 months, and as a result has intellectual and developmental disabilities along with physical impairments.
Oops.
So before we get started, maybe it would help if Ken gave a really quick overview of the main laws, and I'll ask a few questions to spice things up. And then when we're done with that, we can talk about some common defenses and wrap up with a quick recap of the most exciting case that's going on right now, which is the Winn-Dixie case.
Okay, well, I don't know about quick, but I'll try. So there are two basic federal laws involved in web accessibility. Title II of the ADA, which covers state and local governments, and Title III, which covers private businesses, which are confusingly called places of public accommodation under the ADA. We don't see too many court cases under Title II, that's state and local governments, for web accessibility. We do see lots of complaints filed with federal agencies, for example, the Office of Civil Rights, or OCR, at the Department of Education, that are filed against public universities, however, but those never go to court, and they just get settled by OCR. The key concept in Title II is the idea of program accessibility, which asks whether the program as a whole is accessible.
So, Ken, what do you mean whether the quote program is accessible?
Well, it's probably better to look at an example, and a great way to illustrate this is with the lead case in the area for websites, Martin versus MARTA, or Metropolitan Atlanta Rapid Transit Authority. In Martin, a blind plaintiff, well, there were several plaintiffs, but one of the plaintiffs was blind, and he alleged that he couldn't access information from MARTA for going between two locations in Atlanta. MARTA responded by saying that it provided this information to blind travelers in three ways: through a customer service telephone number, by sending out Braille schedules of its trains and buses, and through its website. The plaintiff replied that no one answered the customer service telephone number. The Braille schedules were always incorrect and out of date by the time you received them, and the website was inaccessible. The court found that under those circumstances, Title II was violated. But note that the court didn't specifically say that the website had to be made accessible. It's just that an inaccessible site was part of the reason why Title II was violated. On the other hand, it's likely that if MARTA had an accessible website from the beginning, it could have avoided liability.
Okay, can that state and local governments, but what about private businesses?
Okay, so private businesses are covered by Title III of the ADA and not Title II, which is which I just talked about. And unlike Title II, Title III, which is private businesses, sees a ton of cases for website accessibility. In Title III, we don't have the concept of program access. Instead, in order to be liable under Title III, a business's website needs to have caused discrimination in accessing the goods or services of that business. And the easiest way to create liability is for the website to be inaccessible. But remember what I said earlier about how Title III covers businesses under that term, places of public accommodation? Well, that leads to a natural question about where the place is when it comes to the internet. Obviously, it isn't where the servers for the website are located. And that business may have a bricks and mortar physical store, literally a place of public accommodation, but it's unlikely that that's also where the web services happen. So the question really becomes, how can a place of public accommodation be liable when the inaccessible website isn't in a traditional place?
Okay, wait a second. Even though the ADA was intended to cover private businesses, lawyers and judges are getting hung up about looking for a place just because the law refers to businesses as places of public accommodation.
Yep, that's exactly right. The term place of public accommodation didn't originate in the ADA. It actually derives from the Civil Rights Act of 1964. And there are a lot of older cases that made it really clear that Congress wanted the law to be tied to an old-fashioned bricks and mortar physical place. The world has obviously changed a lot since 1964, but the wording in the ADA still needs to be read in that historical context. And trying to find a place when it comes to the internet has become such a controversy that the courts can't decide which way to go. So our country is divided into 11 regional circuits. And the circuit where your court sits, the court where the plaintiff files their lawsuit, makes a big difference. In years past, I ran through a list of different approaches in the different states, but in the interest of saving time this year, I'm saving that for the handout and just giving the highlights. So the most popular approach is the so-called nexus approach, which is followed in the 3rd, 6th, 9th, and 11th Circuit. Now that includes California, and it also includes Florida on the totally opposite end of the country, two of the most popular venues for plaintiffs in web accessibility cases. And it also includes Hawaii. In these jurisdictions, a plaintiff has to show that there is some connection or nexus between a website and a physical bricks and mortar place of public accommodation. Now, this can be shown with things like a store locator feature on a website or coupons that are redeemable in a physical store that can be downloaded from a website, or being able to place orders online and then later return them at a physical store. Features like that would create a nexus. Now, Florida and the whole 11th Circuit down in the southeast corner of the country is in flux right now because of the Winn-Dixie decision, but we'll come back to that later. The Second Circuit is slightly more liberal when it comes to website accessibility. Here, a plaintiff would still have to show that there's a physical place of public accommodation, but wouldn't have to show that there's a nexus between that physical place of public accommodation and its website. Now, this is important because the Second Circuit includes New York, which is the nation's leader for ADA web accessibility cases. But even in the Second Circuit, there's some dissension, such as in the Eastern District of New York, which is Brooklyn and Long Island, where Judge Comedy wants to make the courts follow the tragic path of the Winn-Dixie decision. And lastly, we've got the most liberal approach, which is followed in the First Circuit and the Seventh Circuit. Now, in these circuits, a physical place isn't required at all. So even a purely online company could be sued. Now, while you might think that these liberal approaches to web accessibility cases would thus make Boston Massachusetts, which is part of the First Circuit, or Chicago, Illinois, which is part of the Seventh Circuit, the go-to venues for plaintiffs, this hasn't proven to be the case, as we rarely ever see web accessibility cases filed there.
Ken, but do these differences really make a difference?
Yeah, oh, very much so. For instance, in 2012, Netflix was sued by the National Association of the Deaf in both California and Massachusetts. Now, California is in the Ninth Circuit, which I mentioned requires a nexus to a physical place. Because Netflix doesn't operate any stores or rental establishments, the court tossed out the case. Now, by contrast, in Massachusetts, which is in the First Circuit, the case was able to go forward because the First Circuit has no nexus requirement. So, same case, same facts, but totally different outcomes because of where the court was located.
Okay, it's a bit confusing how the ADA works, but that overview was really useful. Are there state laws that we have to worry about?
Well, yes, there are a number of state laws, but most of them mimic the ADA. The big one that stands out and that creates separate liability is California's UNRRA Act and Disabled Persons Act. Now, these are two California laws that operate together to provide even greater protections for people with disabilities residing in California. First, UNRRA has a much broader coverage than the ADA and includes any business establishment. In fact, really any business activity, such as arguably even condominium board meetings, are covered under UNRRA. And there's no nexus requirement like we talked about with the ADA. Also, ADA violations are automatically UNRRA violations. Now, that may not seem terribly relevant until you get to the next point, which is that damages are much bigger under UNRRA than they are under the ADA. For instance, a person with a disability, if a person with a disability sued a business because it was inaccessible, the only money damages they could receive is their attorney's fees, even if they could show that the discrimination caused them really big, real financial loss. But if that case were brought in California under the UNRRA Act, then they'd be entitled to 3 times that actual financial loss. And even if they couldn't quantify that loss, or the loss were really small in value, the plaintiff could still recover a minimum of $4,000 per claim. So when the NFB settled its lawsuit against Target Corporation for its inaccessible website, Target Corporation ended up paying $6 million as part of the settlement. And all of this money went to the California plaintiffs. And actually, I think Target ended up with a deal. Now, there are 2 wrinkles to what I just mentioned. First, while UNRRA certainly covers purely online businesses, it would probably be quite hard to receive those same kind of money damages from an online-only business like Netflix, unless the plaintiff could show discriminatory indifference and just really didn't care about the needs of people with disabilities in their website. And second, while UNRRA is a California law, that doesn't mean that you don't have to worry about it if your business is outside of California. In fact, as we'll get to later, plenty of businesses have been sued under UNRRA from across the country. So UNRRA is a very powerful weapon for plaintiffs to have. So it shouldn't be a big surprise that within the last 2 years, we've seen a large increase in web accessibility cases that are filed in California State Court.
I guess it's no wonder then that we have so many website accessibility cases. But let's turn now to some of the real life scenarios that the courts have dealt with.
Okay, that's great. But first, I need to mention something. Very few web accessibility cases go to trial. And so most of the court decisions are made at the very early motion to dismiss stage and before any facts have developed in the case. Now, at that stage of litigation, the judge isn't necessarily saying that the prevailing party will win at trial on a specific issue. Basically, all that the judge is saying is that she wants more evidence before she can come to a conclusion.
Got it. And I get the feeling you're going to remind me about that important distinction in a minute. So I know a thing or two about the ADA. For instance, I know that the principal reason that private businesses need to make their websites accessible is because websites are a form of communication. And the ADA requires that businesses provide effective communication with their customers. So something I've also wondered about, what if a company had a 24/7 telephone number and customers could get the exact same products and services through the phone that they offer on their website? In that case, would a private business avoid making its website accessible at all?
That is a great question, and also a great example of why we need to be careful about reading too much into decisions on motions to dismiss. So the defense that you just mentioned, it was raised years ago in the original Domino's Pizza case. But it's been rejected in a number of cases, like Access Now versus Blue Apron from New Hampshire, or Gorky versus Dave and Buster's from the Central District of California. Then both those cases were back in 2017. But those cases, as I mentioned, were all decided at the motion to dismiss stage. So the judge wasn't saying that Domino's Pizza or Dave and Buster's or Blue Apron couldn't use their telephone number to avoid making their websites accessible. Instead, the court was saying that the evidence might show that a telephone number wasn't an adequate substitute for an inaccessible website. But first, the parties had to go through discovery and gather more evidence.
But didn't the court rule decisively on this issue in Domino's Pizza?
Not in the original opinion from back in 2017. So after the case was decided and appealed and then got rejected by the Supreme Court and sent back to the district court last year, the case went through discovery, and again the defendants argued that a telephone number was an acceptable alternative to an inaccessible website. But this time it was done on a motion for summary judgment, which is different from a motion to dismiss. And it happens after all the evidence has been discovered. So the district court denied that motion because the evidence showed that it took 45 minutes to order a pizza over the phone. And that was not an effective alternative to making a transaction instantly through the web. Plus, there's also a 2018 California state court case called Thurston versus Midvale Corporation. In that case, the trial court said that a telephone number also wasn't an adequate alternative. But that was because the defendant couldn't bring forward any evidence proving that their telephone number did provide an effective alternative. So while we do know that it's hard for a defendant to make this argument, and we really don't know if the court will ever say that a great telephone customer service number is an effective alternative to an ineffective website. But we do know that a lousy customer service telephone number won't help your defense in a web accessibility lawsuit.
Okay, another defense that I hear a lot of companies raise is that they don't control the content that the plaintiff is complaining about. For instance, they may link to YouTube, but someone uploads a video without captioning. Are organizations liable for that?
Well, that's also a great question. So this defense was accepted in Sierra versus City of Hallandale Beach, which was an 11th Circuit case from back in 2018. In this case, the city posted videos of its public proceedings and city council meetings on local cable channels and also through its social media platforms. So the plaintiffs sued the city because those videos were not accessible. And the city asserted that it had no control over the social media sites. The court agreed and dismissed that portion of the case. Now, I don't think that the Sierra versus City of Hallandale Beach case was properly decided, however, because to the extent that the city used its social media sites as part of its program, then Title II would require that that program ultimately be accessible. The bottom line is that organizations have to be really careful with content that they don't control. If it's vital to providing some benefit or opportunity to your customers, think seriously about another way to making that content accessible before just throwing up your arms and claiming that there's nothing that you can do about it.
Ken, one thing that bugs me as a business owner about these web accessibility cases is how opportunistic the lawyers seem sometimes. I'm a big fan of web accessibility, but the lawsuits I keep hearing about involve people who never intended to be customers and only visited a website hoping to find that it would be inaccessible so they could sue the company. Can you say something about that?
Yeah, sure. This issue comes up all the time in these motions to dismiss. I think it comes up in like four different possible contexts. The first three involve something that we call standing to sue, and the third one comes up in something that we call personal jurisdiction. So those are fancy legal terms, but standing to sue means that a plaintiff needs to show that they suffered some kind of injury in order to bring a lawsuit. It's kind of the idea of no harm, no foul. This doesn't have to be a physical injury, but it has to be some kind of harm that the court can redress. So a great example of these cases are the lawsuits against credit unions in web accessibility. So as you know, credit unions often limit their membership to either a narrow geographic region or to a specific class of individuals, such as employees that work for a particular corporation. A few years ago, a lot of credit unions were sued by plaintiffs who had little or no connection to them. Often they lived hundreds of miles away from the nearest branch, and they couldn't meet the basic membership requirements of the credit union. So it shouldn't come as a surprise that those cases were almost always decided in favor of the credit union. In the handout, I've listed a number of those cases, but a complete listing is actually better available at the National Association of Federally Insured Credit Unions, or NAFCU, which has been vigorously defending those cases. Where a plaintiff can't show a genuine interest or ability to be a customer, it's easy to get that kind of case kicked out for lack of standing.
That's exactly the kind of case I hate, where it's so clear that the only thing a plaintiff wants is money. But how else can standing come up?
So oddly, there's a flip side to that standing argument that favors plaintiffs who have zero interest in becoming a customer, particularly in the civil rights context. For instance, in fair housing cases alleging racial discrimination, it can be really hard to show discrimination. So in these cases, the courts have allowed so-called testers to have standing. So in a classic fair housing case, you have two groups of testers who apply for a mortgage or an apartment rental. One group comprises all racial minority testers, and the other group includes only non-minority testers. Now, none of these testers are actually interested in whether they can get a favorable mortgage or a nice apartment. They just want to see what kind of terms they could get or what kind of apartments that they're shown. And then later, a civil rights attorney can bring a Fair Housing Act lawsuit against the lender or rental agent if the minority group is consistently offered less favorable terms or are not shown the nicer apartments. But a bit like the plaintiffs in those credit union cases, the tester doesn't actually suffer an injury because they never had any intent to become a customer or a tenant. Instead, they're representing people who would suffer an injury. So some clever plaintiffs realize that they could try that same strategy in web accessibility cases and assert that the plaintiff isn't actually interested in becoming a customer, but they're representing the interests of other people with disabilities who might be. And here, the courts are really split over whether testers have standing. So again, this is all about wording. Same plaintiff, same facts, but potentially a vastly different outcome depending upon whether they call themselves a tester or not.
So then is there a third way that standing to sue can come up?
Yeah, let's see. Sorry, I'm jumping ahead. Yeah, the last way that we talked about that we can bring in standing. Let's see if I get. I'm sorry, I made a mistake. Right. The last way we can come up in the context of standing is where. Let me see. I've getting a little confused. I made a bit of a mistake here. Let's see. We're on slide 13. That's right. Okay. Yeah. So there's a third way in which standing can come up, and that's where a plaintiff, hang on, sorry, out, um, it can come up is when a defendant says that the plaintiff didn't give them enough information or details about the injury in their complaint. And that's exactly what gives, and that was the thing that gave rise to the injury. So in the context of web accessibility, this third avenue of standing is important because most commercial websites are just constantly changing. So new features are being added, they're being taken away, discounts that can pop up, that can appear in a pop-up that potentially interferes with a user's screen reader may disappear at the end of the month. Now, as a consultant, I can tell you that working on these kinds of cases is absolutely maddening. When a plaintiff doesn't tell you when they visited a website and what they specifically encountered that gave rise to the violation, it can be very hard and expensive for your client to be able to mount a successful defense. On the other hand, I can well understand why a plaintiff shouldn't be required to identify the exact barriers that they encountered and exactly what they did when they encountered a barrier, because then it would be all too easy for a defendant to just fix that one barrier and just get the case dismissed. So at first, it seemed that the courts were taking a fairly liberal stance when it came to what the plaintiffs had to allege. Nevertheless, I've noticed that the courts have become more conservative in how they approach standing when it comes to a plaintiff's assertions. So in one of the cases that I think was particularly interesting, which is Rizzi versus Hilton Domestic Operating Corporation from the Southern District of New York in 2020, the court held that Albert Rizzi had to identify the date and time that he visited a website, the specific deficiencies that he encountered on that website, and how those deficiencies impeded navigation of the website because of his disability. And all that information had to be within the four corners of his complaint, or it would get dismissed. Now, I know Albert Rizzi. He's a friend of mine. I know him quite well, and he's not a serial plaintiff. He's a well-regarded accessibility professional. He's also a founding member of the IAAP, or International Association of Accessibility Professionals. So when he says that he encountered a barrier that made it impossible for him to navigate a website, I'm sure he was telling the truth. And when he says that he wanted to book a room at the Hilton Hotel, I'm sure that that was actually the case, and that he really honestly wanted to book a room. And he couldn't do it. And as a consequence, he suffered an injury. Nevertheless, the allegations he made in this complaint still weren't specific enough to confer standing. So we need to be careful about reading too broadly into that case because different courts interpret standing very differently. So while courts are supposed to follow a more relaxed so-called notice pleading, which is you are just putting people on notice, this has been more restricted within the last decade, and some courts, such as the one Albert faced, have taken this other approach much more to the extreme. And also, in some state courts, they follow a so-called fact pleading approach, which requires that all the details and facts of the case be spelled out in the context of the complaint. So let's see. The last way that the courts have talked about this fairness issue that you mentioned, Natalie, is in the context of personal jurisdiction. So we talked about the three different ways to getting at standing. Now we're talking about the fourth way, which is this personal jurisdiction. The word jurisdiction is such a confusing term, but the idea of personal jurisdiction involves whether a court can really reach a defendant's person. Usually they have to live within a geographic area where the court sits, or at least has enough connections in that geographic region that it wouldn't be unfair to haul them into court. So this defense typically comes up when a defendant asserts that it has so few connections with residents in the district where the court resides that it would be unfair for the court to hold it accountable there, and that a different forum would be more appropriate. So naturally, this can come up a lot in web accessibility litigation. And a perfect example is Access Now versus Sportswear Inc., which was a case from the District of Massachusetts in 2018. So in that case, Sportswear Inc. is an online Seattle-based company. where I live, that printed sportswear such as sweatshirts and t-shirts for sale throughout the United States. Their product line included sweatshirts printed with the names of different colleges and universities throughout the country, including colleges and universities in Massachusetts. You can kind of see where this is going already. So, Sportswear Inc. asserted that it shouldn't not be hauled into court in Massachusetts when it had so few connections there. The court held, however, that by deliberately targeting a market in Massachusetts and by having 4% of its annual sales in Massachusetts, the court had personal jurisdiction over the company. Now, this case demonstrates an important concept. Even if the laws in your jurisdiction suggest that you would not be liable for your online activities, you can still face a lawsuit if your customers are located in a jurisdiction that would favor a lawsuit. So, as you may recall from the beginning of this presentation, Massachusetts is located in the First Circuit, which does not require a nexus between an online business or website and a bricks and mortar physical establishment. Seattle, however, is in the Ninth Circuit, which does require that nexus. Nonetheless, even though Sportswear Inc. couldn't be sued where it was located, nothing prevented it from being sued someplace else. Now, while that may appear to be the scary part, it isn't. Instead, the scary part is when you bring California state law into the equation. So, if you recall what I said at the beginning of this discussion about California's UNRRA and Disabled Persons Act, and you thought, well, that didn't apply to me because I'm not located in California, you may want to think again if you have customers in California. So, earlier we talked about Thurston versus Midvale Corporation. Well, as it turns out, Ms. Thurston was a pretty prolific litigant, and she also sued another company called Collectibles of Georgia under California's UNRRA Act. Even though the company was located at the opposite end of the country, it still had a reasonable portion of its online sales made within the state of California, and this made it subject to California courts and the UNRRA Act. Now, because California represents such an enormous market opportunity, there aren't that many companies out there who will be willing to exclude California customers. But by including California customers, they also make themselves subject to much broader liability for website liability under California's UNRRA Act.
Okay, that's a lot to consider, and probably it's a good reason for businesses to make their websites accessible. Does that really protect a business? And what about if I get sued before I finish fixing my website? Can I get a case kicked out if I just settled another website accessibility case?
Well, those are great questions. And like a good lawyer, I'll say, well, it depends. Specifically, how you settle your case raises potential issues under two legal doctrines called mootness and res judicata. I know that's quite a mouthful. So while they are entirely separate legal doctrines, they are almost indistinguishable when it comes to web accessibility litigation. So let's start with mootness. Mootness basically means that a case has no point in proceeding because whether or not a harm has occurred, that harm has been fixed to the point that a plaintiff can't sue about it anymore. So if I sue my neighbor to have the fence torn down, and the only relief I'm asking the court to grant is for my neighbor to tear down his fence, that case would be moot when the moment that my neighbor tears down his fence. Now, res judicata is a little different. It means that the decisions of one case should be respected in a subsequent case if they raise the same issue. So if I sue my neighbor in federal court and lose, I shouldn't be able to go into state court and bring the identical lawsuit. Again, these are different legal principles, but they can overlap in a confusing way in web accessibility cases. So first, let's talk about mootness. Imagine that you ran a company that was sued because its website was inaccessible. So you settle that lawsuit and start making improvements to your website. Before you completed those changes, however, another plaintiff comes along and sues you again, alleging exactly the same thing that the first plaintiff alleged. In that case, can you get the second lawsuit dismissed? The scenario I just described is basically what happened in Haynes versus Hooters of America, and it raises the legal doctrine of mootness. And Hooters lost when they tried to argue mootness because Hooters had not finished fixing its website, and the second plaintiff had no guarantees that Hooter would live up to its settlement agreement with the first plaintiff. Furthermore, because they were a party to the settlement agreement, the second plaintiff would have no power to enforce the first settlement agreement. So only if Hooters had completely finished fixing its website, and the website was now fully accessible, could it succeed in arguing mootness. So that's mootness. Now let's turn to res judicata. What would happen if in Haynes versus Hooters of America, if that case had gone all the way to trial and the judge had ordered that Hooters of America make its website accessible within 12 months? For the next 12 months, another court would have to dismiss a second case against Hooters while Hooters was still fixing its website because of res judicata. The reason why res judicata didn't protect Hooters, however, was because there wasn't an actual final judgment by the first court. Instead, Hooters settled the case privately in a settlement agreement. But there are lots of ways to end a lawsuit between the two extremes of a private settlement agreement on the one hand and a trial on the other. And one of those ways is through something called a consent decree. Now, on its surface, a consent decree appears to be very similar to a regular settlement agreement, except a consent decree is reviewed and signed by a judge. But being reviewed and signed by a judge makes a world of difference for purposes of res judicata because it makes that settlement agreement into a final judgment of the court. Thus, if a defendant can show that the first plaintiff adequately represented the rights of people with similar disabilities, a defendant could raise a res judicata argument and have the second complaint dismissed against them if they had the judge sign their settlement agreement. Now, this is exactly what happened in the Fernandez versus Dolce & Gabbana case from the Southern District of Florida. Now, normally, getting a consent decree requires a little bit more expense and effort for a defendant because their attorney has to go through the extra steps of having the settlement agreement signed by the judge. But that can make a world of difference in terms of avoiding subsequent litigation while you're trying to actually get your website compliant with WCAG 2.0. Now, this protection by using a consent decree probably wouldn't work, however, if the claim was being brought against you under California's Unruh and Disabled Persons Act, because the second plaintiff's rights, as we discussed, includes monetary damages that were not included in the first lawsuit. But even in an Unruh claim, it would likely be, res judicata would likely be a strong defense in having the non-monetary portions of the claim dismissed. So, plaintiff law firms typically send out dozens of pro forma demand letters and file several hundred, dozens, or nearly identical complaints at the same time. Defendants tell me all the time that if they act quickly, and depending on the market that they're located in, plaintiffs are usually willing to settle cases against smaller companies for $10,000 per claim or less if it's an ADA claim, and about $14,000 or less for Unruh claims. But if res judicata and mootness don't work with Unruh claims, that means that a company could potentially face a ton of $14,000 claims while it's trying to fix its website and quickly be run out of business. Now, I've yet to see that happen, but there also isn't anything in the law to prevent it.
Wow. Okay. I knew law drew distinctions based on tiny technicalities, but this seems kind of extreme. So the process I go through in settling a web accessibility case really can make that much of a difference. You mentioned mootness just a few minutes ago. That comes into play in the Winn-Dixie case, right? Maybe that would be a nice segue to talk about what's going on in Winn-Dixie, Ken.
Sure, absolutely. So first, a little background. So the plaintiff, Juan Carlos Gil, was a regular customer at Winn-Dixie. He lives in Florida, in Miami. Winn-Dixie is a chain of grocery stores in the southeastern states, including Florida. And Florida is part of the 11th Circuit, which we know is a nexus jurisdiction. It requires that there be a nexus between a website and a physical place of public accommodation. So Mr. Gill said that to shop at Winn-Dixie, he would use online coupons from Winn-Dixie's website. And to get his prescriptions refilled, he would like to use the online tool that Winn-Dixie provided so that he could easily get his prescriptions refilled. So he would just walk in and pick them up. But because those features were not accessible, He had to cajole strangers at Winn-Dixie to read him paper coupons. And when he had to get his prescriptions refilled, he had to wait several hours to walk up to the counter and submit his prescription, and then just sit around and wait for the prescription to get refilled. When he could have just walked in and immediately picked them up if he had been able to refill his prescriptions online. So Winn-Dixie was one of those few web accessibility cases to go to all the way to trial. And in 2016, Mr. Gill won. Then Winn-Dixie appealed. And almost 4 years later, a 3-judge panel on the 11th Circuit reversed the opinion in April 2021 and branched out into a whole new interpretation of law that was much narrower than the nexus test. Now, because Mr. Gill could still get access to the services at the store, even though he had to rely on those strangers and waste hours waiting for his prescriptions refilled, the 3-judge panel said, well, that was just too bad. In effect, the court said that unless there was simply no other way to get access to those benefits provided over the web, there wasn't a violation. So, pretty harsh. Immediately after the decision came down, the plaintiffs, joined by the NFB, the National Federation of the Blind, and a host of other disability rights organizations jumped in and asked that the full 11th Circuit, and not just 3-judge panel. There are well over a dozen judges on the 11th Circuit, so this is asking for the whole 11th Circuit to decide on this case. They asked that it's called a motion for an en banc hearing. Also, the plaintiffs argued that Winn-Dixie had long since fixed their website, so the case is moot. Now, I predicted back in June of last year in a webinar for 3Play Media that the 11th Circuit would likely bend over backwards to declare that the case is moot to avoid having the full court decide on the case. And sure enough, in December, the same 3-judge panel issued an order agreeing that the case was simply moot. So that's where the mootness issue in Winn-Dixie comes in. Unfortunately, that's not the end of the story. Now, it's so funny to me how lawyers will seize on whatever argument fits their needs at the moment. When you think about it, the last thing a plaintiff would normally ever assert in any case is that the case was moot. But that's exactly what Mr. Gill's attorneys argued to get the 3-judge panel decision kicked out. And the last thing that a defendant would normally argue is that the case against them wasn't moot. But that's exactly what the defendants argued. In fact, it was kind of funny when I was reading their brief. One of the ways in which you can argue mootness in this kind of case is to say that there's a likelihood that an action is going to recur. And Winn-Dixie said in one of their briefs was, well, we fixed our website, but there's no guarantee that we're not going to screw it up later, so the case really isn't moot. Crazy arguments. But based on what we talked about earlier, the defendants were probably right. This case probably really wasn't moot, or at least it wasn't obviously moot. And so in January, the 3-judge panel withdrew its order, and the case will likely go to the full 11th Circuit. Now, I think it's very telling about how the court tried to get rid of this case. Frankly, I think that the handwriting is on the wall, that if the court can't toss out the case on the basis of mootness, the 11th Circuit is probably going to vacate the opinion of the 3-judge panel and adopt a position that sticks to a traditional nexus test. They just wanted to save the 3 judges from the embarrassment of having their opinion reversed by the full court. I say that because the implications of following the 3-judge panel decision are really quite extreme and would put the 11th Circuit far outside the interpretation by the other circuits. And that means that there's a decent chance that it would get struck down by the Supreme Court if it ever got appealed. So there's a lot of drama going on in Winn-Dixie. Fortunately, unless you happen to be sued by a plaintiff in Florida, or Winn-Dixie actually gets to the Supreme Court and gets them to follow their extremely narrow interpretation of the ADA, it's highly unlikely that any of this drama is ever going to affect you. But it sure is fun to watch it from afar. And I did check this morning, and there was no new opinions in Winn-Dixie.
Wow, that's a complicated story. That brings us to the end of our presentation today and our update on website accessibility litigation. Thank you very much for your attention, and I encourage you to reach out to us. Ken's email address is ken.nakata, N-A-K-A-T-A, at convergeaccessibility.com, and mine is nhadley@outlookbiz.co, not .com. Thanks, everyone.